Hello and welcome to this episode of the DigiPod. My name is Farieha Aziz. Today I'm joined by Hassan Abdullah Niazi, who is a lawyer based in Pakistan. And we will be discussing the court order which has ordered Google to block or remove 27 YouTube accounts from Pakistan. Hassan, thank you for joining DawnNews English. You've posted about this as well, and what's particularly alarming is the court order itself. If we could begin by you pointing out, and as you have posted, the deficiencies in the court order itself and the blanket manner in which this blocking and removal has been ordered.
So thank you, Faria, for having me. So there are a number of problems with this court order. There's not just one. So I want to start first with procedurally, the fact that this court order has been passed under Section 94 of the Criminal Procedure Code of Pakistan. If you read Section 94, it only has to do with the fact of summoning information. It has nothing to do with blocking content. So procedurally, this application has been filed in a deficient manner. So that's the first thing that needs to be looked at, whether or not how this power to ask that entire YouTube channels be blocked is being exercised under this section. The second aspect is that what we in the legal fraternity call that any order has to be a speaking order. What that essentially means is that the order has to be well reasoned, has to confront the facts and evidence, and demonstrate how an offense is made out. Right now, that is not something that this court order does because it doesn't even mention which provision of PECA has been violated. It does not point out what in these channels is offensive, fake, misleading, anti-state, anything, any of those new offenses that they've even added to PECA. It doesn't confront those at all. And the fact of the matter is, Faria, that what this order is saying is not just to block specific videos that might be, let's say, unlawful, but to block entire channels. Now, that would mean essentially that the judge has looked at all of these channels, has looked at all of their videos, and has determined that all of it amounts to an offense. Now, you can see from the order itself that no such depth of reasoning has occurred. So the order by itself becomes legally defective just for the lack of reasons. And the third thing is, I would say that because it's restricting speech, it has to demonstrate that it has confronted the test of restricting speech given in the Constitution, given in various judgments of the superior courts, which is how is blocking proportionate? What is the legitimate state interest that is being served by restricting this speech? And how is it reasonable? And we know from the Awami Workers' Party case of the Islamabad High Court, which deals with blocking of platforms, that due process requirements also have to be fulfilled. So you have to allow the other party an opportunity of hearing, which it seems like did not occur at this stage. So at a very broad level, this order falls apart. It is very, very deficient.
A couple of other things as well. So you mentioned that this is Section 94 of the Criminal Procedure Code, right? And the order itself has the word subpoena. Now, again, how is this relevant? You've been lead counsel formally for Meta, and you've dealt with court orders, blocking requests. It seems almost as if, when the executive requests are vague, as they often are, and they are not complied with by platforms, and then they've latched on to this bit in what we saw in India also, right? Back it by a court order, and maybe the platform will be obligated to comply. And there has been some reason for concern with with YouTube's user notifications because they have alerted these users saying that we have a local law obligation. Could you address this as well in terms of what is a notice and takedown system typically that has to do with takedown requests or removal requests and how this is sort of mixing a lot of things together?
Right. So I think it's a good question and something that a lot of people might be thinking about. First of all, there's really no concept of a subpoena in Pakistani law, right? So I don't know where they have taken that from and why they are using that particular term. Perhaps because they think it's a US company that that term might mean something more. Um, but essentially, like I have said, Section 94 is a provision that deals with summoning of information. So and all of this is public knowledge about how Meta and other platforms look at these sort of requests. But these sort of requests coming from a magistrate under Section 94 were usually about the grant of data. So they would send these notices to companies saying, a criminal offense has occurred. This is the offense. Can you please give us data so that we may further investigate the offense? So, usually in cases of, let's say, child pornography, child molestation, a request like this would come in, threats to women, a request like this would come in, and it would be about the preservation or disclosure of data, right? And the disclosure of data happens in very limited circumstances, but this is not what we're talking about today, but not for the blocking of content. And the reason for that is that the blocking of content, the channel for that is the PTA as per the law. So the PTA under Section 37 of PECA sends a formal notice to social media companies, and that notice has to fulfill certain requirements. And even the companies have come to this conclusion that these requirements have to be there in order for us to consider it a valid notice. And that has to be, it has to specify the offense, it has to give details about how that offense has been made out, and it has to give some reasoning, right, in terms of why blocking is necessary. So that has not happened in this case, as far as we know, right? We don't know if the PTA has also sent a request, but it seems like the FIA is trying to block content through a process that is usually reserved for data disclosure. So when companies get this sort of requests, the first thing they look at is it procedurally valid under local law, which it seems like it's not. Then they look at whether it is substantively unlawful under Pakistan's own law. And that means looking at all the factors that I pointed out. Now, here, what they're trying to do is just because there's a judicial order, they're trying to sort of force the companies to say that, look, it's a judicial order, so you have no business questioning it, which I think is the wrong way to look at it because the companies themselves have bound themselves to what is known as the Global Network Initiative. And that's an important piece here. The Global Network Initiative is a collection of tech companies that have come together and said every decision we make will be in line with international human rights standards. That includes when to block content. When they talk about international human rights standards, in this case, they're talking about Article 19 of the ICCPR. So that means three-pronged test must be fulfilled: legality, necessity, proportionality, to assess whether speech needs to be blocked. That test is not made out by this order.
So the critique when companies complied with India recently during the conflict, when en masse, in a blanket manner, whole accounts were restricted, right? And this was exactly how is it legitimate, proportionate, especially proportionate, that you're
Yes.
blocking it accounts. And now again, we're seeing that this happened, and we learn all the wrong things also from next door. But if you could also elaborate before we get to the procedural part of it, especially with respect to PTA Section 37, the issue here is also the manner in which they've gone about this, right? In terms of how companies, so now YouTube has said that there's a local law obligation. If you could also explain, because there is a difference between, we keep making comparisons to India, but there is a fundamentally different legal obligation there for companies versus in Pakistan, where they are not incorporated in the same manner or have staff on ground. And that does change things, or the market size, even as is often argued.
Yeah, I think that's fair. So in India, we know that social media companies have headquarters and offices and employees. Now, what happens usually in the Indian context is not something that we should be proudly replicating. Because what essentially happens is employees are threatened by the government of coercive measures if there's no compliance. So it is a lot of times these companies are complying under protest. And the case in Pakistan is none of these companies are headquartered in Pakistan, right? Now, whether or not they comply with these requests is essentially to an extent voluntary, because the most that the government can do in terms of penalties is to block the entire platform, as they did in the case of X or Twitter. Because X had been non-compliant with Pakistan's obligations for a very, very long time. And even legitimate requests were ignored. Now we know Google, Meta, these platforms do not do that. They do comply with legitimate requests when they come in, but it is being done, yes, on a voluntary basis. The Indian example is not something that should be replicated in Pakistan, where the BBC, let's forget about social media companies, the BBC or any news organization posts a documentary about the prime minister of the country, and the next day the office is raided. Um, so that by itself is something that the companies, of course, are aware of. And I think by sending this notice, it is probably part of a tiered plan by YouTube to see that, well, maybe some of these channels might go offline by themselves. So it's a chance for voluntary compliance by the users themselves as well. Um, but essentially, the fact of the matter is, even if they were to voluntarily comply, they are still bound by the fact that it has to be legally sound. The request has to be legally sound. And that is not the case here.
And before we get to that, again, how are the users supposed to comply when they've
Yes.
not been told what content violated a particular law, provision of the law, even if it was about, their policy, platform policy, which nothing has been told to the users. And so the user notifications also, in a sense, are deficient in that manner, where they don't give them proper guidance around this. So here's the NCCIA. The FIA has now been replaced by the NCCIA, and an officer making an application to a trial court, assuming the PECA court, under Section 37. But PECA gives Section 37 powers to the PTA, and after the amendments, a new social media regulatory authority, which has not been set up. So in the interim, PTA is to do it. Then the 2021 rules are still in the field, and that also prescribes a procedure. And there's a separate procedure now under the Social Media Regulatory Authority. Now, you said that we should not emulate what is happening in India, right? But we really have, through the rules, etc.
So, the first thing we need to understand is that a lot of times these companies were invited for consultations on the amendments, the rules that were being framed. But frankly speaking, none of these consultations were meaningful in any way. And I don't say this just because the suggestions made by the companies were not followed, but also because there was no one from civil society in the room. There was no one from the journalist community in the room. Now, these are all important stakeholders. If you are going to have a consultation, you need to hear from these people. And that is why they are fundamentally defective. And the fact of the matter is that even after these consultations, all of the problematic provisions that were flagged by the Asia Internet Coalition, by the GNI, by multiple stakeholders were still kept within the law. I believe there was one point where they were amending the rules, where after a long series of consultations, a new draft of the rules came and they had changed absolutely nothing in it. The main point from the government side has always been to try and get social media companies in Pakistan through an office or through officers. And we know why, because that is how you coerce compliance. And the point about India, what needs to be understood is that number one, the offices in India were made a long time ago, before India introduced a lot of its draconian laws, right? So to say that the companies did it despite the laws is incorrect. The companies were already there. The second thing is India is a much, much, much larger digital economy than Pakistan. Pakistan needs to get to that size of a digital economy for it to make business sense for companies to come into the country, right? Which we are not there yet, and we're not making the right steps towards that. We're making it more and more unattractive for these companies to come in. And not just because of the laws, but I'm talking about the general structure of taxes and so on as well. So I think that the problem here that has also occurred is there are the rules, there are the amendments to PECA, there's the Social Media Authority. But if you look at all of that and you look at what this procedure that has been followed is, none of it is even in line with their own law, which they have made to try and make it easier to take down content, but they have not even followed their own law. Let me give you an example. The FIA is supposed to get a complaint, right, of fake news. That's what's written in PECA after the amendments. Where's the complaint? We have not seen it, right? So if there is no complaint, how have they gone to the magistrate, right? That's how criminal procedure works, right? There is a complaint, and then you proceed on the basis of that complaint. So, I mean, to talk about deficiencies, I think any company looking at this request should really think about the fact that what is the precedent they would set if they were to comply with this. If they comply with this sort of request, then I think it's the end of like social media commentary as it is, because all that is needed is for some vaguely worded request to go before a magistrate, and the magistrate blocks entire profiles, channels, and that is a hugely disproportionate response.
Well, I mean, one, the tests of our own laws, but the fact that this is not the forum that is procedurally laid out in law, as we have discussed. And then, but a lot of times we're also talking about how users are kind of sandwiched between corporate interests and policy and then state overreach. Here are people who are then relying that platforms will exercise, their due diligence process properly. But that doesn't seem to have happened, especially with the user notifications. And we don't know whether these restrictions will follow through. And as you say, that this will set a dangerous precedent. Rounding off the discussion also, because you have obviously dealt with various jurisdictions and not just Pakistan, where companies are, and we've spoken about India, but where companies are incorporated, and oftentimes they do comply, and we see that on locally with the ISPs and telcos, which is why it's easier to get compliance there because there's more of a risk and liability. But have you seen pushback also, or how these maybe apply GNI principles or subject them to certain human rights standards, international best practices, or litigate, right, which we see happen in other countries where there are overbroad requests. I mean, there are, as you mentioned, certain ingredients that must be fulfilled in a request. It's not enough that there's a law or even the competent authority may have sent it, but even after that, there's a whole process. Can you cite any examples from other jurisdictions where you've seen pushback or these tests applied?
I think so. The process is the same for the social media companies when they're looking at requests from any country. So I have seen pushback in Bangladesh. I have seen pushback in Sri Lanka, the countries that I used to look at. And I have, of course, when I was part of Meta, seen a lot of pushback against unreasonable requests from Pakistan as well, right? So there is precedent. Even YouTube has done that as well on the basis of its GNI commitments. Because what happens is for these companies is they get audited every 3 years for their adherence to the GNI commitments. Now, if they fail that audit, they get kicked out of the GNI. And for huge companies like this, that's a huge PR blow to them. And you have to think about the fact that when we talk about corporate interest, there is a corporate interest in keeping speech on the platform and not letting it be easily removed. Because if that starts happening, people are just going to shift to other platforms, right? So there is that sort of business interest combined with why the human rights interests come into play. But in terms of pushback, yes, there are numerous requests that have been pushed back on. There is a database maintained by Harvard University called the Lumen database. People can go there and look at the requests that were sent to social media companies, especially Meta. You will see there probably a lot of requests which were not in line with GNI principles, which resulted in a pushback. And I personally have been part of a lot of those decision-making processes where we decided to push back based on human rights considerations. Even under intense pressure, I might add, just for all the viewers. But yes, so there is precedent. And I think this is a case where pushback is merited, both legally, both on a human rights standpoint, and also just for the precedent that it might set.
Hassan, just finally, sort of concluding comments. Also, if you could point out, what can companies do better? Because there's definitely room for improvement across the board. But specifically with respect to transparency, you've mentioned Lumen, we have transparency reports. But again, one of the critiques among civil society also is that we don't get enough qualitative data or reasons and explanations and why certain decisions are implemented or not implemented. And I know that even Meta set up the oversight board and some decisions get reversed. But in terms of specifically user notifications or the processes, because now some of them may have to respond to YouTube, take it up with them as well. What is it that the companies should be doing in this particular context, but generally when they receive this, and what kind of information should be a part of user notifications? Because like you said, the only thing that's been referenced is there's some inquiry, they don't know what the complaint is, and there's a vague court order, and there's no guidance in terms of what they should be doing about the content, and there can be penalties. Their accounts could be restricted, or there can be strikes against them.
Look, I think the biggest problem that I have seen is that the way, and looking beyond this particular case, people do not know what sort of requests the PTA is sending to social media companies and what they look like. Maybe you've seen some, but the vast majority are kept under secrecy, right? So it's between the companies and the PTA. I think that is the biggest problem because if people started seeing the type of requests that the PTA is sending on a vast majority of basis, there will be a lot of pressure on the PTA to do better, right? Because remember, this is a regulator not tasked with censoring speech. This is a regulator tasked with keeping online spaces safe. We should not forget that. So, is the bulk of its time being used to keep online platforms safe for children, for women, for vulnerable minorities, or is the bulk of its time being spent sending notices like this? And if we start seeing those notices, then people on the ground can start challenging those notices. Civil society can start lobbying government authorities, show them those notices, show them the links that they are claiming are anti-state, are prejudicial to national security. And I personally just want to say that some of those links that have been sent saying that they are prejudicial to national security are laughable. Like, frankly, they are laughable. Memes are not going to be a threat to national security. It, that level of transparency needs to be there. And social media companies can provide that because we know the PTA is not going to do that. I think there are a number of right to information requests that are pending that nothing has been done about them. So social media companies can do that by showing users that, hey, this is the request we got. And users will then have at least some empowerment, right? But there needs to be more information coming out in terms of what sort of requests are being sent. Because right now, there's no accountability for the PTA for the type of takedown requests that they are sending. In this case, in the YouTube case, we at least have a higher level of digital literacy by the people who are affected. To a large extent, because they have faced a lot of these issues, they are aware of their rights, right? They are aware of what they can do. But the vast majority of the population, when they get a notice like this, they're going to be scared, right? They don't even know what they have done wrong. So how can they correct their behavior? Even from a state level, it makes no sense to not share this information with people. It's between companies and the PTA, and things are either getting blocked or getting pushed back. But the user seems to have no say. So that I think is the biggest problem, the lack of transparency in terms of what these notices actually say.
And like you said, that right to information requests are made, and either there are no responses or responses belatedly. And we've seen that the few challenges that have been mounted before courts, and especially the Islamabad High Court, you referenced the Awami Workers' Party case, but that in itself is illustrative of the fact that they went around to the PTA, to the Election Commission, and then finally in court because they never were intimated or they never were told. And that's precisely what the High Court order held, that you have to give notice to somebody if you're taking adverse action against them. And here we are so many years later, and a trial court is repeating the exact same things that the High Court had said you're not supposed to do.
Yeah.
When
I don't think, I know that currently we are in an environment where there's a thinking that not much is going to come through legal avenues. But I think the challenges should not stop, because the challenges force the higher judiciary to confront these problems. They force the authorities to confront these issues that people are facing, and people should not back down, right? The pressure should be kept sustained by mounting these legal challenges, right? Because it is your right and that should continue. The second aspect, of course, is that civil society, journalist bodies should also make their voices heard to social media companies. They should know that what sort of environment is happening and what sort of precedents will be set by complying with orders such as this, right? Now we have representation in the Global Network Initiative. Pakistan does have representation. The Global Network Initiative should be doing what its job is, and checking on these companies whether or not they are complying with these sort of requests. And that is also where Pakistan needs to be talking. They need to be talking to the GNI that this is the environment we live in. Social media is one of the few avenues left where we can legitimately exercise our freedom of expression. So these sort of orders cannot be let go of. We cannot say that there's nothing we can do and let's hope for the best. We need to keep raising our voice against this.
Hassan, thank you so much for making time for Dawn News English. This is all that we have for today, and we will obviously watch what happens going forward with these YouTube accounts and how YouTube responds.